Good afternoon, gentlemen. Called the meeting to order. Will the clerk please start with the city council roll call?
Councilmember Sullivan?
Here.
Councilmember Bowen? Here yet? Councilmember Bash? Yes. Mayor Pro Tem Grunmeyer? Mayor Newton?
Here.
Thank you. And for Planning Commission, Member Young?
Here.
Member Shu?
Here.
Member Hedges?
Here.
And Vice Chair Acevedo is absent. Thank you.
Okay, thank you, Sophia. I'd like to call upon Erica. Good afternoon. How have you been?
Good afternoon, Mayor. I've been well, thank you. Mayor Pro Tem, council members, members of the Planning Commission, thank you for having me here this afternoon. I'm Erica Vega with the law firm of Burke, Williams & Sorensen, and I was asked to come and present to you on new housing laws in California for 2025. So the agenda for the presentation is a brief overview of California housing law, just to make sure, I know there's some new faces and that everyone's on the same page about the lay of the land with respect to housing regulation in California. And then I'll jump into some specific changes of interest to Norco for 2025. And discuss more specifically how those changes may impact your city, and then hold some time for questions and answers at the end. But before I jump right into the meat of stuff, I do want to introduce myself a little bit more because there are a few faces that I don't recognize that are new here. As I said, I'm Erica Vega. I'm a partner in the Riverside office of Burke, Williams & Sorensen. I've been practicing for 18 years, representing cities as city attorney and special land use and housing counsel. And I've been working with the city of Norco since 2021. So jumping into the overview of California housing law, it's a very, very complex subject. I'm just going to put that out there first. So this is sort of the highlight reel, the main points that I'm not going to, go into great depth. We would be here forever, and you wouldn't remember half of it. So really, these are like the key takeaways that I'd like for you to hopefully remember when I leave here today. So the first main law that you should be aware of, and is, I think arguably the most important when it comes to meeting bodies, is the Housing Accountability Act. So this is a very complex statute. It has a lot of different parts, but I think the key takeaway of most importance for the city of Norco is this restriction right here on the ability to disapprove a housing development project or to condition it to be at a lower density than what they're proposing. You can't do it unless you can make certain findings, as long as that project is consistent with all of your objective standards. The findings that need to be made do vary depending on whether it's market rate or it's affordable. So I haven't gone into detail on what those findings are, but they are rigorous findings. They need to be supported by what we call the preponderance of the evidence, which is a higher evidentiary standard than most decisions need to be supported by at the council and planning commission level. There's quite a few other parts of the Housing Accountability Act. You've probably heard of the builder's remedy. That you don't have to worry about so much because that really only applies to jurisdictions that don't have a certified, which you do. But it's something to keep in the back of your mind if knock on wood, you were ever to find yourself in a non-compliant status. Another major set of laws, it's called the Housing Crisis Act. It was adopted in 2019. And the purpose of this act is really to limit your regulatory authority, I guess. It doesn't apply to individual projects so much as it applies to what kinds of regulations you want to adopt to then apply to projects. So some of the examples of the regulations that it limits are the ability to reduce the intensity of residential development to below a level from what was allowed on January 1st, 2018. You can do it, but in order to do it, you have to take an offsetting action, which we refer to as no net loss. So in other words, if you have the capacity for 100 units on this site and you want to have that to 50, then you kind of have to find somewhere else to put those 50 units. It applies on a parcel level. It also applies at like a citywide level. So if you have a total development capacity, when you're doing sort of wholesale rezonings, you do have to look at it in a citywide level as well as on an individual level if a project came through and requested a reduction in the density. Another example of a regulation limitation in the Housing Crisis Act is it prohibits enforcing design standards that are not objective unless those design standards were adopted prior to January 1st, 2020. And it also prohibits adopting moratorium on housing or caps on housing. There can be some exceptions there. If you can get approval from the Department of Housing and Community Development, and to that I say good luck. I can't think of a single instance where I think they would support a moratorium or cap on housing production. Another set of laws is the housing element law, which is part of the general plan law. So your housing element is one of the required elements of your general plan. You have a housing element, and you have a compliant housing element, and that's fantastic. The general gist of this law is that you are required to have the housing element, and it gets updated every 8 years, excuse me. As a part of that, the biggest hurdle, the biggest component, the component that gets the most attention is identifying adequate sites to meet your, what we call RHNA numbers. And those are numbers that are given to you through SCAG to identify what are your, not quota, it's not the right term, but you have to plan for this number of units, or at least have sites available if that number of units were to ever come to your city. Most cities don't see that number come through, at least not in this general area. But SCAG will assign you a number. They'll break it down very low, moderate, and above moderate income, and you have to plan for all income levels. The accessory dwelling unit law is also really important. It gets a ton of usage. And what it does is it requires you to have to ministerially approve accessory dwelling units as long as they're consistent with your local ordinance, and then the state law puts maximum restrictions on what you can require of accessory dwelling units. It also has a provision that puts parameters on how many accessory dwelling units you have to allow on any individual site. For single family, that is 3. Which would include 1 detached accessory dwelling unit, 1 conversion of existing space within the home, and then 1 what we call junior accessory dwelling unit, which is also a conversion of existing space, but it's capped at 500 square feet. I should say there are exceptions to this. So this doesn't allow someone to come in and do a 1,500 square foot detached ADU plus a 1,000 square foot conversion, and there are limitations, and it's 800 square feet on the detached. So if someone is coming in with a detached ADU that's larger than that, then it's kind of outside the scope of this, and you can apply your local restrictions versus what's in the state law for what we call statewide exemption ADUs. And then we have a slew of affordable housing laws. And I've just given you 3 examples here that either have come up in Norco or in other cities I represent generally in the Inland Empire. There are a lot more, and they tend to be pretty niche. So these are some of the more generally applicable ones as well. So the first you may have heard of is SB 35, and that provides streamlined ministerial approval to affordable housing projects. They have to be at least 50% affordable to lower income households. That percentage can vary depending on your progress towards meeting your RHNA numbers. But for you all right now, it's 50%. And for most jurisdictions, it's 50%, because unless you are on track to meet your RENA, you kind of are subject to the higher percentage amount. If the project's consistent with your objective development standards and meets the list of objective eligibility criteria in the statute, then it's planning director approval. It doesn't get approved by planning commission or city council. It has to be approved at the staff level. Another law is the density bonus law, and this one is really, really important and gets invoked more frequently now than it did in earlier years. It provides a sliding scale of density increases depending on how much affordability they're providing. So a project that is 20% affordable is not going to get as big of a bonus as a project that's 100% affordable. So there are large tables, so I haven't included that level of detail here. But the important thing to note is that what we're seeing more and more now are developers that are providing the bare minimum affordability to qualify. They don't take the density bonus at all. They don't want the increase in density. What they want are these other bullet points, the incentives and concessions, and the unlimited development standard waivers, and the parking ratio reductions that come. As long as you're entitled to take a density bonus, you can get those even if you don't actually use the density bonus. So that's unfortunately a way that we're seeing a lot of developers nowadays try to get around development standards, of your objective development standards, by providing some bare minimum affordable units and invoking the density bonus law. Another example, SB4, this applies to land that is owned by either an institute of higher education or a religious institute. It has to meet some certain statutory requirements, and if it does, again, it's use by right if it's 100% affordable. And lastly, I added this slide for, I think, fairly obvious reasons right now. There are some laws regarding fire safety that I think are important to remind you all of in this day and age, pertaining to existing housing mostly, as well as building standards for new housing. Excuse me. The state, in response to the devastating fire season in 2017, thank you. You may recall, I believe it was the Camp Fire up in Northern California, adopted a new set of laws that required the state to identify existing subdivisions, which is defined as residential developments with 30 or more dwellings that are within high fire hazard areas, including state responsibility areas, and identify mitigation measures, for lack of a better term, to help mitigate the risk of loss of life, essentially, from not having sufficient egress. The Camp Fire, if you recall, there was one way in, one way out, and that was the major cause for the inability of people to evacuate properly. So we have that, and that law also requires the state to do your updates to your fire hazard severity zones. I believe new maps are coming out soon. Staff has told me that you can expect to see, you'll have to adopt those. There used to be the ability to modify the maps to make them reduced scale. That does not exist anymore. You have to adopt the maps as proposed or expand the zones. So if you have the evidence to support expanding your fire hazard severity zone, you can do that, but you can't reduce the fire hazard severity zone from what the state recommends. Okay, so that's just sort of a general overview of the restrictions the state places on local agencies with respect to housing development in California. And so part of my job is to go through the volumes of legislation that gets proposed every year to keep changing what the rules are. This year, I want to say there was approximately 60 bills that impacted housing in some way, shape, or form that got approved by the legislature and signed by the governor. Some of those don't really have direct impact to cities. They're things like funding, bills, and whatnot. But what I've got in these next set of slides are the ones that have direct impact to cities and, more importantly, potential direct impact to Norco. When I was conferring with staff, they really want to make sure that I don't overwhelm you with a comprehensive review of laws, many of which you may not have too much interest in or may not have a ton of impact here. So I'll try to keep it focused on things that I personally think are worth your consideration in time and review. And I tried to group them together topically as well. So this slide right here discusses 3 bills that pertain to the housing element. The first one, AB 2023, has to do with your compliance status. Previously, there was some argument, I guess, that an agency, a city or a county, could self-certify their housing element as compliant, and this bill took that away. It made it clear that the only way your housing element can be compliant is if HCD or a court has said it is compliant. So there's no self-certification option. And it also kind of shifted the burden of proof. I'm moving on to AB 1866. So that shifted the burden of proof. It's a little technical, so I won't get into the weeds, but essentially, if you ever got into a dispute over your compliance status, it used to be that there was a presumption you were compliant, and then the burden was on the other side to prove you weren't compliant, and now it's a presumption of noncompliance if you have a noncompliant status, and the burden is on the agency to prove your compliance. So they've just kind of done this flip-flop of whose responsibility and whose burden it is to justify compliance or noncompliance. One other thing I want to mention is HCD has increased, or the state has increased HCD's ability to enforce. They've been given some new enforcement authority of various housing laws in California. They've also been given the ability to impose monthly penalties if they bring an enforcement action and you're found to be in violation. So those penalties can range from $10,000 to $50,000 a month. And it clarified that the Attorney General's office or the state is authorized to get full cost recovery in any action that they bring over compliance issues where they're successful. And this is not just for violations of the housing element law, it's for violations of any housing law where you're required to ministerially approve the project and they find that you have in some way violated that law, most likely by not ministerially approving the project. But there's other potential violations that could occur. This bill, AB 1893, has gotten a lot of press. I'm going to keep it focused. Most of the press, if you've seen any, pertains to the builder's remedy, which, as I mentioned previously, you don't really have to worry about because you have a compliant housing element. Builder's remedy is an option for developers to propose a development that's 20% affordable and essentially do whatever they want. And this puts parameters on that, but the parameters are sky high. But it does some other things, and for the purposes of Norco and many other jurisdictions that I work with, the most significant change proposed by AB 1893 is it significantly expands the list of actions that constitute a disapproval of a housing development project. So if you remember from the previous section, this act says that you cannot disapprove a housing development project that meets your objective standards unless you're able to make certain very rigorous findings. And so we used to say, well, what is a disapproval? You know, it's kind of the common sense answer. It's, well, you vote no. A majority votes no and does not approve the project. Now it is much broader and includes things such as violating the 5-hearing limit, which is an existing rule that says you can't hold more than 5 public hearings on a project. There was no remedy initially for that. You know, there was no identified remedy that said, you know, And if you do, here's what happens. And so it was an open question, and they have answered that question with this bill. So if you exceed 5 hearings or you get to the 5th hearing and you don't have an approval, then it constitutes a disapproval. There's also some staff level actions that can be considered disapproval, including asking for things on the developer to submit things in an incomplete letter that weren't identified as a part of the application materials as something they needed to submit. Same thing for asking for something on a second or subsequent review of the application that wasn't asked the first go around. So it's kind of a one-shot deal. And then there's this kind of catch-all provision that says a developer can allege that the agency is engaging in a course of conduct for improper purposes, whether that's to stall the project, make it cost prohibitive, anything that the developer thinks may be improper. They can allege that constitutes a disapproval of the project. And there's a procedure for them to do that. They have to submit a notice to the agency that they believe that is happening, which then triggers essentially a public review period. The notice has to get posted to your website. You have to take, it doesn't say a formal public hearing, but you have to take public comment, and then the city has to review all of the comment and evidence it receives during that period and render a determination as to whether you will or will not cease the alleged improper course of conduct. And if you decide not to, then that gives them the ability to go to court and sue. Okay, accessory dwelling units. Believe it or not, this year they were a little light on the accessory dwelling unit regulation changes. In previous years, it's been a lot more extensive. So this year there was 2 major bills. SB 1211 made a few cleanup changes that I would suggest you incorporate into your ordinance, but it's not the end of the world. But then there's one substantive change where it has increased the number of detached accessory dwelling units that have to be allowed at an existing multifamily development from 2 to 8. That's the only real major substantive change. Everything else was cleanup. Now, there were substantive changes to the statutes that pertain to ADU amnesty. So I'm aware that you all have adopted an ADU amnesty program to help legalize existing unpermitted ADUs. Now, the state has gone and expanded the state's ADU amnesty provisions. It used to be only apply to unpermitted ADUs constructed prior to 2018. They've upped that date. Now it's prior to 2020. And it limits the basis for refusing to issue the permit and allow the ADU to become legalized. You can only deny that permit if the ADU has a substandard condition to it, and substandard conditions are defined in the Health and Safety Code. And there are some noticing requirements, public information requirements about having that information on your website readily available for people who want more information on being able to legalize their ADU. And it also impacts your ability to charge impact fees and connection and capacity charges on the existing unpermitted ADU. Okay, there was a lot of movement on fees this legislative session. So this first one I want to highlight for you pertains to traffic impact fees. There is now a reduced impact fee statute for certain types of qualifying housing developments that the state considers to generate lower trips. That has to do with whether they provide lesser amounts of parking, so therefore have less vehicles parked on site, proximity to major transit stops, and also proximity to neighborhoods serving retail. And then this bill on top of that, in addition to the fee component, severely restricts the ability to require dedications for roadway widening purposes of new housing development. If the purpose is to mitigate traffic impacts, you can still require it if the purpose is for safety, things like sidewalks, protected bike lanes, things like that. But if the purpose of it is to mitigate traffic impacts, then that has been taken away. So you may want to look at any existing impact fees and dedication requirements to make sure that you're retaining your ability to require dedications for safety purposes rather than roadway widening purposes. Another bill, this one was SB 937, impacts the timing of collection of impact fees, pushes it to certificate of occupancy or final inspection. And then there's even some more limitations to that allow further delay as long as there's an agreement in place securing the fee collection. These next two bills have to do with public information and developer information. One is about providing fee estimates to developers and requires that estimate to be provided within 30 days of request, so this is like a timeliness issue. The developers want to have their estimates in a timely manner, and there was nothing requiring the city to provide estimates within any specific turnaround. So we now have that obligation. So it's 30 days of a request at preliminary application and then also upon project approval. And then for you all, since you have an inclusionary housing ordinance, this bill has delayed effectiveness, so it gives you a full year to get up to speed, but starting January 1, 2026, there's certain information about your inclusionary housing fees, what you collect, what you plan to use them for, things like that, that are going to need to be available on your website. And then there are a couple of bills extending the life of existing development permits. So AB 2117 extends the life of any development permit automatically to cover the appeal period plus any time that is spent in litigation over that. So if you, some agencies do not put expiration dates on their permits, others do. So if you do, then you just kind of have to make sure you're tracking that if you are in the situation of litigation. And then AB 2779, we've seen the legislature do similar things before where they just sort of unilaterally give extensions to existing entitlements. They did it again, giving 18 months to any housing approvals that were in effect on January 1 of 2024 that were set to expire by the end of 2025. So any projects in that window automatically get an extra 18 months to pull permits and start construction of their project. Okay, and there's a lot more, like I mentioned. So this is just a partial list to give you a flavor of some of the other bills that I think are of lesser impact to Norco, but you know, you still should be aware of. And this is just a partial list. It's, you know, what I could reasonably fit on the slide without everyone squinting and saying, I can't read that. So the final section, it's really short, one slide, kind of like going through what I think, based off my review, are some impacts to Norco at the high level or at the preliminary level, at least, from some of these bills that I've just talked to you about. So the first is probably the most obvious one, was looking at updating your accessory dwelling unit ordinance to make sure it's fully consistent with new laws. And also revisiting your ADU amnesty program to make sure it's fully consistent with the state's new ADU amnesty program. Like you're allowed to provide more amnesty, and that's fine. But we want to just make sure that you're not in some way, shape, or form providing less amnesty than the state is providing. And this is not so much an action item as a, you know, keep doing what you're doing item. You already have your HCD certification of your housing element, and you really want to make sure that you maintain that through the 8-year planning period. because of the potential consequences of losing your certified status, being builder's remedy projects. The amount of density, I mean, if you lose your compliance status and you were to get a builder's remedy application, they could propose just something so astronomically dense, way, way, way out of keeping of anything that you see, not just in Norco, but anywhere in this area. And there's really almost nothing you could do about it. It's a really severe consequence. So I just want to really emphasize that. And so at the staff level, some of the other things to avoid being deemed to have disapproved a housing project, you want to review application forms and checklists to make sure they're comprehensive. They include all the information that the city is going to need. I'm sure they do, but sometimes it's always a good practice to review those things every once in a while and make sure that they're current. And that way we don't get stuck in a situation where the city is looking for information and can't ask for it because it's not a part of the initial application form and checklist. Same thing with your fee policies and practices. There was 4 fee bills that I noted there, so you just want to make sure that you're collecting your impact fees and other fees at the right time and in compliance with the new laws that impact the ability to impose fees, including making sure that you've got procedures in place, or at least someone is alert to the fact that people can now request reduced traffic impact fees if they have a qualifying project. One bill that was on the and more slide that I just did want to highlight briefly here is there's been an increase to the amount of notice that has to be given for planning commission hearings only, not city council hearings, on zone changes and zoning text amendments if they impact the use of property. So if you change the zone, that obviously impacts the uses that can be built on property. If you amend your zoning code to change the list of permitted or conditionally permitted uses, that would also trigger this additional notice period. They've doubled it from 10 days to 20 days. So it's just not, more public notice sounds good, but it's just something to be aware of in the planning process to make sure that all the deadlines are being met to get your notices mailed out into the paper, so to make your agenda publication and meeting deadlines. And then finally, staff let me know that new fire hazard maps are on the way, and when those are available to you, you'll have 120 days to adopt them. And I believe that, you might, if you are interested in seeing whether you can justify broader fire hazard areas, you would want to undertake whatever work you need to do to gather the evidence to support that. It does have to be supported by substantial evidence. You can't just say citywide we're entirely a fire hazard area, unless that's what the state's telling you at least. So with that is the end of my presentation, and I'm happy to answer any questions you may have.
Thank you, Erica. Colin, do you have anything you need to say on any of the new laws?
I was going to do a presentation on new laws also. I don't have any questions about Ms. Vega's presentation.
Okay. Let's go ahead and let Colin do his presentation, then we'll put all the questions
Sounds good.
together.
Great. Thank you. Good evening, Honorable Mayor and council members and commissioners. We have finished another legislative year. As usual, there were many laws that impacted cities. I want to go over a few tonight. This isn't going to be comprehensive. Cal Cities actually puts out a PDF that deals with all the laws that they believe impact cities. I'll send that over. What I wanted to do is touch on some highlights, and particularly some highlights of laws that impact Norco. Before that, just take a look, how does a bill become a law? So in its simplest form, it's introduced in either the Senate or the Assembly. If it's introduced in the Senate, it's SB. The Assembly, it's AB. It goes to committee. If it passes a committee vote, it goes to the full Senate, the floor. If it passes that vote, it goes to the other House. If it passes there, it goes to the governor. The governor can then sign it and it becomes a law, veto it, and it's not a law unless it's overridden by 2/3 vote of the legislature, or wait 12 days and it becomes a law. So this year, there were 1,200 laws that made its way to the governor. The governor vetoed 189 of them, so by inference, 189 bills became law. Cal City's actually introduced 13 bills himself on wildfire mitigation, sober living facilities, Brown Act, and some other areas. What I heard from our legislative representative at Cal Cities is one of the takeaways this year. The governor and the legislature really underestimated the public's opinion on a few areas, including homelessness and retail theft. So I do want to go into a few of those. Looking at retail theft first, going back to Prop 47, you'll recall that in 2014, the voters adopted Prop 47 that reduced many felonies to misdemeanors. The point of Prop 47 was to reduce prison population, overcrowding, and California was also under a federal court order to reduce substandard conditions in prisons. So Prop 47 was supposed to take care of that. The outcome of Prop 47 was an increase in property crime and retail theft, and there was also an underreporting of the crimes because they weren't getting prosecuted. So there was an uptick, and recently a substantial uptick in retail theft, smash and grab robberies, which was also fueled somewhat by decisions of some DAs saying that they're not going to prosecute low-level offenses. So there was a public backlash, and the legislature had to come together, put aside their political ideologies, which is that misdemeanor-type crimes should avoid prosecution, and put together a 10-bill package that was aimed at kind of beefing up the laws on retail theft. So 10 new laws were adopted. Here's a few of them. First, jurisdiction. Normally, when a theft or a crime occurs, the DA has to prosecute in the same county that the crime occurred. This law allows all of the crimes across the state for retail theft to be aggregated. So when you're looking at organized crime, what the organizations will do is they'll go and hit a store in one county, then the next county, and then the next county, knowing that if they get caught, they're only going to be prosecuted for one violation. In this case, if you have a number of stores that you hit in different counties, they can all get aggregated into one case, one trial, and really help the DAs clear through some of these cases. The next sentencing enhancements, they're increasing the penalties for retail theft. The new penalties, a court shall impose, which makes it look mandatory, shall impose an additional term of 1 year if the retail theft is over $50,000, up to $3 million if it's over, up to 4 years if it's over $3 million. Okay, this next provision was the major law that was put forward on retail theft. It has multiple provisions. First, under existing law, a person can be charged with grand theft if the property taken exceeds $950 during the course of distinct, as in different, but related acts. So what this does is it expands what related acts are. It says related acts can include multiple victims, it can include acts in other counties, and it can also include acts that are similar in nature or within a 90-day period. So a criminal organization can't argue that, it's been 3 months, so they weren't distinct. It was against different people, different areas. The DA can now say that all those things are part of a related set of retail thefts and charge for grand theft instead of just petty larceny. Also, existing law prohibits generally officers from making an arrest for a misdemeanor that they didn't see. It's called the stale misdemeanor rule. So usually for an officer to make an arrest on a misdemeanor, they have to either witness it or a person has to make a citizen's arrest. And you might have heard somebody having to sign a citizen's arrest form. That's because of the stale misdemeanor rule. An officer is supposed to witness a misdemeanor to arrest. Under certain exceptions like domestic violence, an officer can arrest for a crime that he does not see, even if it's a misdemeanor. What this law does is it adds retail theft to the list of crimes that an officer can arrest for, even if the officer didn't see it. So if you have somebody in a store, a security officer that's able to make a citizen's arrest of an individual, they can give that person to the officer can arrest even if the officer didn't see the crime. Okay. Another retail theft bill deals with retail theft restraining orders. So most stores know who's robbing from them. And this law allows a judge, when sentencing a defendant for retail theft, to also issue a criminal protective order that prohibits the person from going back into the store, or from going into the parking lot, or if it's part of a chain, from going into the other chain locations or franchises. So if a person does theft at a Target, gets prosecuted for it, and the judge issues one of these orders, that person can no longer go to even the parking lot of another Target. So it's very effective for stopping organized retail theft of large chain stores. The DA or other persons on this list can also do it even without a conviction if you have a district attorney that isn't prosecuting against somebody who's had 2 or more arrests for retail theft. Online marketplaces. So under existing law, online marketplaces have to require high volume sellers to disclose certain information. This bill casts a wider net for who is a high volume seller. It also requires a policy prohibiting the sale of stolen goods, which is probably a good idea. Also have a mechanism to notify the online marketplace that goods are stolen, and it allows the enforcement by the Attorney General. So it requires online retailers, large online retailers, to take some additional steps to see that stolen items are getting reported and things are done to prevent stolen items from being sold on their platform. Another law, SB 1242, deals with setting fires while apparently organized crime groups were going in and setting fires in a retailer's premises to cause a distraction so that they could rob the premises. This makes that an aggregating factor in sentencing for arson. So arson generally is a wobbler. A wobbler means it can be charged as a felony or a misdemeanor, and whichever way it's charged, a sentencing judge will also look at aggravating or mitigating factors. This says that if you set a fire, commit arson in the course of a retail theft, that's an aggravating factor for purposes of sentencing, and I think also for purposes of charging at the DA level. Another law, this goes along with the other law that increased the punishment levels based on the amount. This is a sentencing enhancement for selling, exchanging, or returning for value any property that was stolen. So not just the entity that steals, but also the next level of person who purchases the stolen property and tries to make a profit off it by selling it or returning it to the store. Finally, Prop 36. So the stakeholders, retailers, and DAs got together, and they didn't think that the 10-bill package from the legislature was aggressive enough. So what they did was they put forward Prop 36 on the 2024 November ballot. Prop 36 allows felony charges for thefts under $950 if there are 2 theft convictions. This is to deter repeat retail theft. Cal Cities supported this bill. It was overwhelmingly approved by the voters in November. Okay, moving past retail theft, homelessness. There were a number of laws meant to address homelessness. Most of them were aimed at the county or the state. A couple of laws do impact cities. One, AB 3093, deals with the housing element, and it requires that we account for the housing of people experiencing homelessness by adding 2 new income levels. One is acutely low income, and the other is extremely low income, to look at how many persons in these income levels are in our jurisdiction and whether there are housing opportunities for them. The next, AB 1782, allows up to $500,000 of successor agency money to be spent on homeless prevention and rehousing. This is actually going to be very helpful for public agencies that are trying to put persons in hotels to create a short-term bridge housing before you can move them into more permanent housing. What I've heard from homeless advocates is that a person has to be in some sort of temporary housing for at least 6 months before they're eligible for more long-term permanent housing. This will help cities bridge that 6-month gap. And also, if a city has a shelter, obviously that'll help the operation and maintenance. A couple of laws relating to animals, AB 1988. That basically just says that puppies or kittens relinquished by their owner are immediately available for adoption by a nonprofit animal rescue or adoption organization. The next deals with warming centers. If the city has a warming center designated in an emergency plan, if practical, we're supposed to designate at least one pet-friendly warming center. The next, ACR 86, deals with spay and neutering services. It says that it encourages cities to develop and fund high-volume spay and neuter centers. It's more of an encouragement request. It doesn't provide any funds for cities to do it. Next is more interesting. It deals with connectivity and the conservation element. So cities are required to have a conservation element in their plan. This requires cities to include a wildlife connectivity element in their general plan update. And what it looks at is how new development will impact wildlife movement. So it's going to be interesting to see how the presence of wildlife movement, natural pathways for animals, impacts some future developments once we start looking at this portion of the conservation element. Sober living homes. We did get 2 helpful laws on sober living homes. The first one, AB 2081, requires licensed or certified alcohol and drug abuse programs to include something on their website that allows a person going to the home to check their license status. So basically what it allows them to do is if a person's going into a home, they can confirm whether the licensee is on probation, has any discipline, things of that nature. It's a warning to persons going into the house. It's also supposed to motivate the group home operators to follow the rules so that they don't have one of these marks on their record. The next looks at sober living homes as part of integral facilities. So the way that some sober living homes will operate is a treatment center is regulated, and there's no contention of that. Where they get around the regulations is with the single-family residential homes. If you have a group of people living together as what's called a single housekeeping unit, meaning they share the same chores, they share food in the refrigerator, they have to be treated like a normal single-family home. There's no permits, no additional regulation. So what group homes will do is they will buy a treatment center, license it, and then buy a number of single-family homes and put the residents of the treatment center in the homes and say that all those homes are single-family units and they can avoid all of the regulation of the homes themselves. This looks and determines whether those are all part of an integral network to see if they actually should be regulated. And it allows Department of Health Services to have oversight in that. What I have seen recently is the homes have gone even further, and what they're doing now is instead of providing treatment in a home, they're using treatment by Zoom. So the residents will have a certain treatment time. They'll go down to the computer, sign on to their doctor, who is a doctor of the actual group home itself. The doctor will be at the treatment facility rather than at the home, and then the group home will say they're not treating persons at the homes, or the persons are going on Zoom just like they would in their regular home to get around the requirement that they get a license for treatment in the actual residence themselves. Okay, we got a couple of helpful laws on revenue. First, dealing with tiered water rates. Under Prop 218, water rates are supposed to be reasonably related to the cost of service. A gallon of water is a gallon of water. The Capistrano Water District several years ago charged a higher price for persons who used high levels of water. It was a tiered type of pricing. And the Court of Appeal looked at it and said, whether you use 5 gallons of water or 1 gallon of water, the price is going to be the same. So you can't do a tiered water rate for higher uses consistently with Prop 218. This bill opens the door back up to tier water rates. And what it says is that local agencies can recognize that public works departments have to add additional infrastructure. There's capacity expansion involved for people who use higher water rates. So it has opened up the possibility, better argument for arguing that we can tier our water rates, charge additional charges for high water users. The next one is remedies for violations of Prop 218. Before a Prop 218 violation happened, the local agency was required to refund the over-collected fees. Under SB 1072, instead of having to refund all the over-collected fees at once, what local agencies can do now is to credit them against future bills, which allows us to amortize some of these judgments if we ever run into one. It really protects the public funds, public fisc, allows cities to plan for adverse judgments on Prop 218 cases. Okay, we got a few election laws that came through. First, AB 2642. This prohibits intimidation or threatening a person engaging in certain election-related facilities. There is, under this law, a presumption that if a person open carries a firearm or an imitation firearm while they interact with someone, that is per se, or at least presumed to be engaging in intimidation. That presumption can be overcome. One of the ways to overcome it is to say that, multiple persons in the community all carry firearms. That's the nature of how the community works. So, in that case, it is an intimidation, but it does create a presumption for a person who open carries a firearm around elections workers. The next one, defending democracy from deep fake. This requires large online platforms like Meta to remove or label materially deceptive and digitally modified content. It applies 6 months before an election. Basically, it requires private online censorship of speech. Next is AB 2839, deceptive media in advertisements. This prohibits any campaign advertisements that have been digitally altered in a deceptive way. So here we're going to run into another possible First Amendment implication, both with requiring large platforms to remove what they believe is materially deceptive, and also now looking to see what is digitally altered in a deceptive way in political advertising. So we are getting into a lot of speech issues with some of these new laws. Next, SB 1174, voter identification, it prohibits it, even if you're a charter city. And elections are one of the quintessential foundational charter issues. And so the legislature has said that even a charter city cannot require voter ID. I think there's a charter authority conflict there, and we'll see if the courts take a look at that. Got a couple of Brown Act laws. First, under teleconferences. The normal teleconferencing procedure is that if a member wants to teleconference, we have to have agendas at all teleconference locations, and that teleconference location, whether it's a hotel or wherever, has to be open to the public. There is an exception that allows a teleconference location to not be open to the public in cases of good cause or an emergency. Under prior law, a member could use the good cause, it's actually just cause, or emergency for 20% of the meetings. Under the new law, the new allotment is if the legislative body meets twice a month, the legislature can miss up to 5 meetings per year. So for this city, up to 5 meetings per year based on just cause or an emergency, teleconference without having to disclose the teleconference location or open it up to the public. The next one, critical infrastructure. This says that a city can discuss cybersecurity threats in closed session. I was surprised the legislature had to bring this one forward. I think that most city attorneys would say that you could do this under threats to public facilities anyway, but I guess there were some issues with it and the legislature decided they had to clarify it. A couple of miscellaneous laws. Housing and historical resources. Apparently the legislature is starting to question the use of historic resource designations as it comes to development. So what they are saying is that cities now have to report historic designations of 1 year prior on their annual planning report. The city of Norco has a historic district that has existed for several years now, so that was good timing on that. Another is AB 3024 that deals with hate littering. Hate littering tends to happen to local politicians. When a politician's running for office, what people will do is they'll deliver hateful literature to their home. This says that hate littering is a violation of the California civil rights laws. And the last, there was an Andrew Doe amendment. I'm sure you heard what happened in Orange County with a gentleman who decided to give large contracts to a nonprofit corporation that was owned by a family member. There's laws that were meant to address that. I am available for questions.
Thank you, Colin.
Thank you.
Let's go ahead and start with council questions for either Colin or Erica. Kevin?
So for Erica, I have several questions. First off, we should just get rid of the planning department, just so we're clear. I feel sorry for you guys. Interestingly enough, co-author Senator Roth, who co-authored SB 35, in a recent conversation said he didn't know what the impact would actually be. So we really appreciate the fact that he was not reelected. To my questions. Insurance. If we expand the fire zone, does that also expand the ability for the insurance company to say, oh, fire insurance, you're going to have to go to the state fund?
I don't know off the top of my head on that one, whether a local action to expand the very high fire hazard severity zone, what kind of impact that would have on the ability of your homeowners to get property insurance. That's something I'd have to look into. But I can say, as someone who lives in a very high fire hazard severity zone, it is problematic getting property insurance at this point in time.
Yeah, we anticipate it'll get worse. So if in fact you live in a high fire zone, and let's say you don't have the ladder truck to get to the third floor, can you say, we're sorry, we can't build?
It depends. So I think, first of all, if you're building 3-story, like an apartment complex in a very high fire hazard severity zone, that's sort of like one separate issue. Like typically you'd want to zone those properties for lower density, and some of the laws, like SB 35, exclude very high fire hazard severity zones. So you can't propose an SB 35 development in a high fire hazard zone.
So if in fact we end up going to a tier 3 or God forbid a tier 4, which would affect your entire city, our entire city, could we just say, okay, sorry, no more building? I'm just asking.
Yeah,
Which, by the way, would be very wise.
From a fire hazard standpoint, I can definitely see that position. Whether from a legal standpoint, you could justify a complete moratorium on all new building. I don't know that I could answer that off the top of my head.
Okay, well, I'm just curious.
And
I'll get
typically, they would raise also takings issues that you would need to consider as a part of that as well.
I mean, you know, like all the new buildings you're building there in Eastvale, you've got all those big high apartment complexes. If a fire ever sweeps through it like Pasadena, you will not be able to put out all those fires. And so it's impossible because you don't even have a ladder truck yet. So I don't mean to pick on you guys, but we have the same problem. We have all the hotels and things. So just curious, 5 hearings, does that include the developer going out and talking to the public?
No, so
Okay.
that is, the definition of hearing in that particular statute doesn't match with what you think of as a public hearing, like a noticed public hearing. It's more expansive, but it is limited to hearings and meetings that are conducted by or required by the city, the agency. So it doesn't include things like the developer proactively holding a community meeting on their own part. But it covers all of your planning commission meetings, all of your city council meetings, regardless of whether the item is a hearing item or a business item.
Okay. SB 1211, so I would assume that applies to duplexes to go from the expanded.
1211, sorry, I don't have the presentation in front of me. Could you remind me which one that is? There's a lot of numbers. Oh, it's the ADU one. Yes, thank you. Yeah, so multifamily
So that'd be a
includes
duplex or a triplex. The school district, one of the things that's killing us on trying to expand our forgiveness program, our ADU, is the school district they're telling us they still consider it new construction, so they want to charge an impact fee of $22,000 to $30,000 against the new. It's not new. Some of them have been there for 50 years. When we try to bring them into compliance, we've waived pretty much all of our fees, but they're saying they don't want to waive their fees. Do those impact fees include what the school district?
I would have to double check, but I don't believe so. I believe it's the impact fee reference that is used as to your Mitigation Fee Act impact fees.
So I would actually like to find out if in fact the school district is correct, because that is we have hundreds of these things in Norco, and we can't do anything because the school district, and they can't give us the laws. I'd like to find out if in fact we can tell them to go pound sand, because we would like to bring them into compliance. And then my last question, I actually have a bunch more, but I'll get you later. I have one other question for our attorney. Thank you. 1889 Conservation Element Wildlife, so horse trails. Sorry, there's a horse trail. What does that mean exactly? Does that mean that along just just areas where we know that there's conservation easements, that there's, critter trails?
No, I think it's broader. And what we're hearing a lot is the coyote paths out in between Orange County and Riverside. There's a lot of those, and as you have freeway construction, that blocks them. So I think it's a natural area of movement for some species, and I think it'll be something that's going to come up probably significantly in some areas. I think in less developed areas, you'll have some nature paths are going to have to be looked at, and I think it's going to be a difficult hurdle for some developers to come up to clear when you start looking at these things. So
It's too bad, because all along behind the Navy base, the college into the new development, that was actually a pass-through area. And then my last question is for both of you, and I'm sorry it took so much time. I understand there's a new law that says that you can get credit not to build. Riverside's doing a pilot program if you want to preserve open space in order to stop traffic. Do you know what that law is about? Dana was going to look into it, but she got hurt. So in other words, it's a pilot program in Riverside where if you can go ahead and maintain open space because you're saying, wait a minute, I'm not going to build, so that'll keep more cars off the road. It's the vehicle miles traveled issue. And I'm just wondering if there's something that we could leverage to maybe not have to build some of the things that they're forcing us to build. So
maybe reduce the fees for.
I don't know how it works, but if somebody would contact Riverside, the mayor seemed to know quite a bit about it, and I was just curious if either one of you knew something about it. Thank you, Mr. Mayor. Thank you.
Thea? Robin?
Thank you, Mr. Mayor. So my only question, and it would be, I guess, Erica, is if AB 2533 does apply to our school district partners, because they are our biggest stumbling block for the impact fees in our amnesty program.
I don't want to speak with 100% certainty off the
Right,
top
no,
of my head, but
it's-
I'll make a
If you
note
can
of
just
it and
find
I'll
out for
find
us,
out.
yeah.
Yep.
Thank you.
Even if they don't have a leg to stand on, because it's not new construction.
I didn't see you sneak in, Bowen. Have any questions?
Kevin already asked it. My biggest concern was if we were to go ahead and expand our fire, with everything coming down, with the insurance companies revoking everything, is that going to put our people in the city more in danger of not getting fire insurance? That was my only concern. And then that was the only one I had.
I think it would. If our fire danger goes up on the fire maps, I think it will be a problem for insurance.
Okay. Planning Commission, Patricia.
Just one question for Erica. On the Housing Crisis Act, it says enforce design standards adopted after 1/1/2020 unless objective. That has nothing to do with our architecture requirements, or would it?
If your architectural requirements were adopted after January 1, 2020, and they have any subjectivity to them, then it would apply. Yeah. So anything subjective or objective that predates January 1, 2020, you have a little bit more leeway. There's still some restrictions in other laws, just not the Housing Crisis Act. But anything adopted after January 1, 2020 has to be objective.
All right, thank you.
To be enforceable, at least.
Thank you.
Is that it? Tara?
I have a couple questions. Let's see. With affordable, the definition of affordable, does that change or does that stay pretty constant? How often do they update those numbers?
Technically, it can change law to law. In practice, most statutes refer back to the same set of definitions in the Health and Safety Code. And those pretty much haven't changed in quite some time. And it just goes by percentage of income pegged to whatever the median is for your area. So a household that makes 80% or less then the area median income is considered a lower income household. And then there's different percentages for very low, which I want to say is 50%. Above moderate is up to is 120%. So everything above 120% of the area median is considered above moderate, and that window from 80 to 120 is considered moderate.
Okay, so it generally pretty much stays constant?
Yeah, it's been really constant for quite some time now.
Okay, and when you say area, is that by county, by city, by, when you define area?
Yes, so it's generally county, but what we actually use is it's numbers and figures that come down from the Federal Department of Housing and Urban Development that then filter down to the state level, that then filter down to the county level. And so there's consistency there. It all stems from numbers that HUD initially prepares as a part of their Section 8 program. And then we just utilize those figures and numbers.
My second question has to do with the fire safety, and this is something that's been weighing on my mind even before this presentation, about what can the city do to be proactive, not only to protect our city from fires, but to help protect our citizens from dealing with insurance issues, because I know many of us have dealt with insurance issues. So I wanted to even know, can the city be proactive? I know we're waiting for the state to kind of come and say what it is, but can the city actively be proactive on that and create our own measures? And is this something that we can legally do to maybe work with insurance companies and find out, what can we do, and just basically ask them directly, what can we do to make ourselves more fire safe and more insurable for our people?
Yeah, that's a great question, and it's obviously a huge concern, statewide, and especially here in Norco, even where I live. I don't practice in insurance law, so I'd be kind of stepping outside of my scope of expertise there. But, safety has multiple components, and some of which I addressed it can be addressed through housing and development laws. You adopt your new building codes every 3 years. As a part of that, you have the ability to make local modifications that you believe can be justified based off of your local climatic or geological conditions. And so you have that ability there to look at what the building codes and what the fire code says with respect to new construction and safety, and make adjustments that you might think are appropriate. And then the fire laws that I mentioned in my presentation pertain to, addressing safety issues with your existing development, which, could be recent existing development. It could be quite old existing development that was, built way before we had the kind of wildfire issues that we're currently having in California. And then that's a budgetary issue as to what the city can, reasonably afford, what's appropriate versus for the city to do versus is more of a individual private homeowner issue. And that's a big project, a big undertaking to look at, and you probably need a plan of some sort in place. And I'm sure all of that would have impacts on the insurance market's willingness to insure property within Norco.
Just to step into one of the things we learned about, I'm sorry.
No, go ahead finish your questions.
Oh, that's it.
That's it? Kevin?
Sorry. One of the things I'm going to bring up tonight is something called the Climate Resilience District, which is exactly something that we can do that I talked to the insurance folks today. We can create within our town districts that are climate resistant, which means safer fire-wise. So that may help.
Jeff?
Yeah, Erica, I've got a few questions for you. And when I look at laws, I tend to think about loopholes. So
Me too.
if I'm fully expecting some of these to be, I don't know, I'll look into it. So here we go. In terms of the density bonus law, you were saying that some of the builders are looking in terms of looking at the incentives rather than kind of these other methods. But one of them is the parking ratio reduction. Do you know if it has any specific language in terms of parking sizes, in terms of standard parking versus compact parking? Because I think in our design standards, because we have much more big trucks, we had some more info in there.
I don't believe so. I'm pretty familiar with the housing, with the density bonus law, and I can't think, I don't recall seeing language about parking spot dimensions, but I would need to double check that. It's primarily the ratios, which is how many spaces need to be provided per bedroom in the unit.
So in the case where we're talking about primarily standard size parking, they, in theory, would not be able to just convert them all to compact sizes.
In theory, yeah, and I don't know what the regulations are with respect to the ability to provide, say, all compact in a parking lot, or whether there's any limitation on being able to do that or not.
Next one, on the Housing Accountability Act, in terms of submittal and the number of the 5 hearing and the requirement for the submittal to kind of be complete the first time it comes in. One of the things is that I know that typically we have a counter technician who takes in the information, and the reviewer, whether it be the building or planning, they don't actually look at it at the time of intake. So if say the checklist says site plan and they submit a site plan, but it's missing information, like it doesn't have all the spot elevations or something, and the planner, when he gets to it and sees, hey, we need some additional information there, even though it's submitted, would they be able to say that counts as one?
No. So when you physically take in the paperwork, that's not the equivalent of a determination of whether the application is complete or not. The Permit Streamlining Act has deadlines that need to be followed, and so that once you take it in, then that starts the clock on the deadline to determine whether the application submittal was complete or incomplete. And Alma, I can't believe I'm blanking. It's 30 days? It's 30 days. There we go.
Okay, on the ADU and the amnesty program, I know that we're kind of focusing on trying to get them accepted, and the law is making it as easy as possible, but I guess my question is the reverse. If somebody has an ADU that they're looking for amnesty and they are going through the paperwork, do we have the ability, depending on our design standards, to revoke it, like, or to put limitations on it? Like if they have an ADU that is bright pink and we want it to be repainted to earth tone?
No, is it substandard as defined in the health and safety code, or is it not substandard? That is the
not be able to-
criteria. That is the criteria, yeah.
All right, and the last one on the fee estimates for the applications, it says 30 days. Now my question is, a lot of these applicants come in for extensions. When they file for extension, does that open the door for us to reassess the fees if the fee schedule has changed during that time period?
It depends. If they've submitted a preliminary application for a housing development project, at least, that locks in typically the development standards, including the fees that are going to be applicable to what was in existence as of the date of their submittal of a preliminary application. That being said, if they come in with a modified project, that might reopen. And it just depends on whether the modification that they're proposing to their initial submittal is big enough. There's percentage thresholds and whatnot, and we kind of need to go through and figure out whether all told together, it adds up to, I believe it's 20%, a 20% change to what they had initially proposed, and then that would reopen it to a new grandfathering date, essentially, with the revised submittal.
Okay, last question, kind of on the same line of reasoning on the AB 21117, or 2117, extending the development permit timeline. What if it's an applicant-driven request?
So if an applicant comes to you and submits an application under your existing ordinances for an extension of time, that's going to be separate and in addition to whatever they're entitled to under this statute.
Okay. So if they came in with an issue of their own that extended the review time period, they would not be able to deduct that or
Yeah, well, they would if they're thinking ahead. they would look to make sure that they don't apply for an extension of time that pushes their expiration date out so far that they are no longer eligible for the automatic extension of time under the statute. I think that's probably unlikely to happen because it is an automatic extension of time. So technically, I think all of these projects have been extended effective January 1 of this year, regardless of whether it's been noted in the paperwork yet. Yeah.
That's all I got, Greg. Thank you.
Thank you, Jeff. Just a couple.
Okay.
To the commissioner's question on safety, since we are doing the general plan, we should have that opportunity under the safety element to strengthen that, correct?
Yes, yeah, you have your safety element. There's different ways you can, address safety through your general plan. And also, there are some, now that I didn't even think about it, that you were in the middle of a general plan update, there are some bills that I didn't really discuss in detail that trigger reviews of general plan elements. A good example of that is SB 98, the warehouse bill, that says by January 1 of 2026 or 2028, depending on where you're located, you have to update your circulation element to address truck routes. So if you're in the middle of already updating your circulation element right now, you could go ahead and just do it now, do it early, so you don't have to revisit it again in a few years.
Okay.
There's a couple others like that as well. But yes, but to the fire issue, yes, your safety element addresses fire hazards.
And I'm trying to find more ways to be creative about this is, and I would suggest that take a look at the Norco Ridge Ranch specific plan. There's an entire chapter on fuel modification. And then maybe with the safety element, we can start asking for more fuel modification. But Norco Ridge Ranch is where we first started looking at that, on that criteria. Back on Housing Accountability Act, within infrastructure, the concerns for water demand, and not is there an opening where we can just get past the will serve letter?
That's a difficult for me to say off the
Okay.
top of my head. Like I can't
I
think
mean,
of
no,
anything.
and I
any
feel fine
changes.
if you want to
Yeah.
get back to all of us on it.
I mean, that's more of a creative strategy
You're
type
right.
of type of question. And it's not that the law has been updated to address that issue. you know?
Okay. But
Yeah.
in the middle of the night when you're thinking
Yeah.
about it, you can get back to us on that.
my 3 a.m. thoughts.
And then just a clarification on the ADU unit law with the 3 ADUs. That still can't impact our 40% lot coverage, right? It has to stay within the 40%,
So if
and our animal keeping areas with that.
No, unfortunately.
Really?
So I want to just make a distinction. So again, so the requirement that you allow up to 3 ADUs only really kicks in if they have submitted for what we call a statewide exemption ADU, which again, it has to be less than 800 square feet if it's detached. And there's a few other restrictions on height and things like that, and exterior access. But if they propose something that is in line with that very limited requirements for a statewide exemption ADU, the law specifically says now, effective January 1, that you cannot impose any additional local standards. If they meet that checklist, they qualify for a building permit. Now, if they don't, so for example, if they come in with a 1,200 square foot ADU, that's outside the scope of the statewide exemption, then they do have to comply with your local ordinance requirements.
Okay. That's not very happy.
I'm gonna build a bright pink ADU right next to Greg.
Erica, Appreciate it, thank you.
Thank you.
Colin, just one question for you, and this was on homelessness, on successor agencies, or it even may be a Lisette question. Do we have any money in our successor agency that we could use to, if so, to help pay for our homeless programs that,
Yeah, we're actually have a meeting next week with RSG, our consultants, to discuss funding for
and we could
housing.
use that to offset our costs?
That's one of the questions we have on which types of programs qualify.
All right. And I'm just going to leave this as a general comment, trying to keep us creative. When you brought up about wildlife corridors, there is a major wildlife corridor under the 91 freeway from the mountains to the south that run to Green Valley, Green River Golf Course. And that's mostly for big cats and, you know, tigers and bears. But also, that which we have, taking that degree of it, in Moreno Valley, under a lot of their roadways, they have to have rattlesnake access. And so, I mean, there's a, yeah, but, so there's a wide parameter that, you know, we can maybe use that to our advantage if we need to. So, if there's no further questions, does the city clerk, do we have any public comments?
I have no public comments for this item, Mayor.
Thank you, Sophia. Then what I'm going to do is ask the planning commissioners, thank you for attending. It's good to see you all. And you're welcome to stay. We're going to move into our special meeting, items 1A. And this is going to be our Community Development Director.
All right. Good evening, Council.
And I'll let you do the introduction of
Yes,
the item.
yes. Good evening, Council. This agenda item is basically the introduction and adoption of an interim urgency ordinance establishing a temporary moratorium on new hotels with kitchens in their guest rooms and amending Norco Municipal Code Section 18.02.04, definition of hotel to prohibit kitchens in restrooms. Excuse me, in guest rooms, my apologies. So the recommendation here is that the city council adopt an interim urgency ordinance to prohibit kitchens in hotels. Basically, right now, our ordinance allows that 10% of the units in a hotel be allowed to consist of kitchens. This interim urgency moratorium will basically put a stop on that for 45 days to allow us to study to see if there's any changes, and there is an opportunity to expand that moratorium. So with that, we are recommending approval, and Colin and I are here to answer any questions that the council may have. Thank you.
Thank you, Alma. Does council have any questions of staff at this time? Okay, hearing none. Does the clerk, do we have any public comments?
I have received no public comments for this item.
Thank you, Sophia. Okay, we'll bring this back to council discussion and action. Robin, would you like to start?
Yes, thank you, Mr.
Take a
Mayor.
minute.
Sorry. Is there something specific that has prompted this concern? Or is there a huge problem with existing facilities, or is it a combination of things?
It's a combination of things. Recently, when we were dealing with extended stay off the freeway, council expressed a desire to discontinue extended stay uses. One of the hallmarks of an extended stay use is kitchens. There was thought about whether additional hotels with kitchens would create more of an extended stay use. So we're asking council to provide us a chance to study it. 45 days to take a look and see what we're looking at, what kind of how kitchens impact hotels, whether they automatically lead to extended uses, really what we want to do with them.
And the particular hotel in town, is it 100% kitchens? Is it the 10%? What's the percentage of kitchens in that? That,
I'm not sure what the extended stay
Development is.
percent is. I thought that, I don't know.
Okay,
The
that's
room
fair.
that we went and toured several months ago had a kitchen in it, and I believe they said, it was represented that most of the rooms, if not all, had kitchens.
okay. Thank you.
Greg?
Yeah, I think that's something we really need to look into, and I'm for it 100%.
Kevin? Fia? Okay. Well, I think this is something we should be at least discussing, and do you have anything else on that? I mean,
Well, no, I'm okay, I guess, with the moratorium on new hotels, but I don't see extended stays like knocking down the doors to come to Norco. Usually you're only going to see one or two of them. I guess when the research is being done, if we can find data on who's using, like, who are the customers that are using those particular types of rooms, and would there be any potential impacts to maybe weekend use of those? So I'll just put it out there, like if you are a person traveling with 15 to 20 high school kids, at least having one room with a kitchen to be able to feed those kids because you can't afford to take 30-some kids out to dinner makes a difference. So I just want to make sure, I understand why we're doing the research, but I want to make sure that we are not going to create undue hardship on some of the activities that are taking place at Silver Lakes by prohibiting kitchenettes in some of the rooms. So,
And, well, my understanding is this is only, it's not moratorium on hotels, it's
right, it's on the
moratorium
kitchens.
on the 10% require, or 10% allowance of total rooms can have kitchens. That's how our ordinance is today, correct?
That's correct. Only 10% of the rooms can have kitchens. So right now, and you're correct, the moratorium is for basically just the kitchens, just no kitchens at all. But hotels can keep coming in, but just no kitchens.
So on that, with the ordinance, that, I mean, you could change the 10% to 5%, or you could change it to 0.
No, I understand how it
Okay.
works. I'm just
Good.
asking for
All right.
accurate data so we can make an informed decision. That's all I'm asking for.
This question.
Yeah, Kevin, absolutely.
So for me, and I totally get where you're coming from. There's a difference between the Stay Bridge that's built in Eastvale, which has all kinds of amenities, has a lobby, has all kinds of stuff, and the one we have, which the top floor is a geriatric ward, literally. There's no lobby, it's sort of like a downtown hotel, the old type. So maybe as we look at this, we need to look at, okay, if you want this, there needs to be amenities in which a soccer team would be attracted to. Because I didn't realize they were stay bridges, or they were extended stays, but I used them many times when I traveled with my teams because I
Right.
kept them all together. But I think it's the amenities that go with it that's important.
And I agree with you on that. Having stayed at, like, a Stay Bridge, indoor pool,
Yeah.
large lobby, restaurant area, things like that, where we don't have that in our present form. So I think that,
Because
that's a
we're
good
now,
point to look
the
at
guy
those
does
amenities
want to
with this.
He does want to meet with us now, with you.
Okay, we can keep that off.
Right, so.
Right. Okay. So is that possible to make that part of that study within the next 45 days if we do allow 10%, that it must have those amenities? All right, I'll entertain a motion.
Mr. Mayor, can I read title? And also, this
Yeah.
ordinance will require a 4/5 vote.
Okay.
It's an interim urgency ordinance of the City Council of the City of Norco establishing a temporary moratorium on new development hotels and amending Norco Municipal Code Section 180204, definition of hotel to prohibit kitchens in guest rooms.
I'll entertain a motion. Second. Councilmember Bowen seconds. Would you like to do, we're going to do this verbally, correct? Okay.
All right, Councilmember Sullivan,
Yes.
Councilmember Bowen,
Yes.
Councilmember Bash. Yes. Mayor Pro Tem Grunmeyer,
Yes.
Mayor Newton.
Yes.
Motion passes unanimous. Thank you.
Okay, thank you. We're now going to adjourn to closed session for regular and special meeting closed session items. Will the city attorney please read all the closed session items?
Thank you, Mr. Mayor. We are going into closed session on anticipated litigation, closed session on existing litigation, FPPC versus Norco, conference with labor negotiators, and conference with legal counsel, anticipated litigation regarding a property owner requesting a sound wall.
Thank you. And we'll now. Absolutely. Here's the keys, Mike. Good evening. I'm going to reconvene the public session. Colin, would you like to address closed session?
Thank you, Mr. Mayor. Council discussed the FPPC versus City of Norco item. There was no reportable action. Council discussed the sound wall anticipated litigation item. There was no reportable action. Council gave direction to staff on both matters. Council did not discuss the initiation of litigation or the labor negotiations. Both of those were moved to the end of the meeting, which means that the special meeting and the regular meeting will continue to run concurrently.
Thank you. We will now have the Pledge of Allegiance by Councilmember Bash and the invocation by Chaplain Bruce Smith from Cowboys for Christ.
Ready to begin? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Kevin. Good evening, Chaplain.
Good evening, Council. I appreciate this opportunity to speak before you and open your meeting this evening. I'd like to start the invocation tonight with a moment of silence out of respect to Deputy Timothy Corlew, who left this earth on January 8th, 2025. Dear Jesus, you teach us in your word that the calling of guardian warrior is a post that you take very seriously. You mentioned it in the Bible, and that those who answer it are called to it. Deputy Corlew raised his hand, took an oath, and protected the citizens of Riverside County with honor and integrity. Dear Jesus, we pray that you're greeting him with open arms, and the angels are rejoicing over him. Lord, we ask for your hand of comfort and love over his family, his friends, and his co-workers. Dear Lord, we ask for your hand on this body tonight. We ask that you give them wisdom and strength as they lead this city today and in the future. Lord, help them in all their decisions, and we pray that in the difficult ones, the ones that are confusing, the ones that are cloudy, that they turn to you for your wisdom and guidance. And finally, Lord, we pray tonight for those still on the fire lines, the first responders, the firefighters, that you protect them and watch over them. And dear God, send your comfort and love over the victims over this tragedy. And Lord, please bring it to a swift conclusion. We pray this in Jesus' name. Amen.
Amen. Thank you, Chaplain. Okay, I'm going to call upon Doug Grove with RHA Landscape Architects Planners, who's going to give us a short update on our Parks and Recreation Needs Assessment.
Great. Thank you, Mayor. Thank you, Council.
Evening.
Excited to be here to give you a little update on where we're at on the Parks Master Plan. Started last February. It was our first meetings we had with some of you and the community, so excited to be here and show you where we're at and give you an idea on where we're going to be going as we wrap it up. One of the first things we looked at and always look at is the community profile, which obviously Norco is very unique. We do a lot of these master plans, a lot of places, but none with agricultural and equestrian like Norco. And I've been doing work in Norco for over 25 years, so I was excited to be involved in that. We also look at the population growth now and what we think it's going to be in the coming years. We're also lining this up with the general plan update. So this is actually a chart from their report that we're tying our stuff into. So looking basically at around 4,000 or 5,000, or about a 4,000 person increase over the next 26 years, 25 years. So that all gets factored into what we're looking at in the overall plan. We also look at the age segments to see where we are today, where we've been. You can see as we move forward in the next 15 years, our population is going to age, obviously, going to about 35% is going to be 55 and over. So that also factors into, as we start to recommend things for the city to be implementing in programs and amenities, that will be a factor. We also look at the income levels. Norco's a little unique here. As you can see, on the left is Norco's per capita and also in household income compared to California and the United States. Per capita is about the same, little probably on the lower end, but the household income is very much higher, and we attribute that to a lot of multiple family members living in the same household generating income. So what that does is it takes a per capita income and it raises it up a little bit higher so that the families can afford to participate in more events and more community events and more sporting and different activities for recreation. We also look at something called the Market Potential Index, and what this measures is the potential demand for a product or activity within a specific area, in this case Norco, and we then compare that to local consumer behavior to national averages. So it's kind of what people would buy. They look at purchasing habits, and they can see how these relate to the rest of the nation. Unfortunately, don't track equestrian or animal care in those charts, so we are doing that on our report as well, but the charts you'll see here don't have that. We look at it from a general sport, so the blue line is national average, the gold is where Norco falls in those, and these are things that the city residents could engage in both inside and outside of Norco, but just taking on things that they purchase and things that they do. This is how they look at where their priorities are and what could be happening with the residents here in the city. Fitness, everything in Norco above average, so a very active community, which is good to know as we prepare our recommendations for the plan, that we have a community that wants to be out and doing a lot of activity, a lot of exercise. Outdoor activities, bicycling, hiking, mountain biking, a lot of trails here, obviously, on top of the equestrian, people doing that, hiking and biking, and then fishing, backpacking, and the only things that are a little below the national average are the archery, rock climbing, and fresh water. We then got into the park assessments. So we looked at all of the parks that the city maintains. We didn't do the LMD parks, mostly up in the hills, because those are paid for by the residents and not paid for by the city. So we looked at the 10 parks, or the 12 parks you can see here, total about 85 acres. Created a map of the entire city. This is all in our GIS system, Geographical Information Systems, that the city can also have as well when we're complete, showing that most of the parks that the city maintains are on the east side or west side of the city, a few on the east side, and we also did not include Ingalls because it's pretty much a standalone event center that doesn't really play into the Parks and Rec Master Plan. We went to each park. We have a device we take out there that ties into the internet to our GIS system, and it logs every element of the park. So at the trash can, playground, restroom building, it's all logged in electronically, and so we now have a database of everything in all of your parks, and we also rate those on a scale of 1 to 5, so we can tell you how many good benches you have, how many great benches you have, or anything else we have in the park. So what it does is it gives us a snapshot of where we're at today, so we start to recommend improvements. Some of the improvements may just be deferred maintenance things that need to be taken care of that haven't been been done prior to this. We also look at each of the parks in 4 different areas: access and connectivity, condition and functionality, safety and comfort, and maintenance. So we get ratings then for each park on a scale of 1 to 5 on how they fit all of those elements. So we don't just go out there and say, oh, it looks good or it looks bad. This gives us an idea. So as we go back to make recommendations, we know if we fall short in any of those 4 categories, those are things we're going to try and do to make the park a better park and make improvements there. We also looked at the programs that the city runs. We had the 6 categories that they have now: the athletics, citywide special events, contract classes, developmentally challenged, senior programs, and youth programs. We just sent over a draft report to the city staff. They're reviewing that right now. It's about a 20-page analysis of all of these programs. So we'll be making recommendations on programs that maybe need to be put aside, they're not doing well anymore, and some things that, based on the public input, that we want to start adding to the programming. A lot of public input. We went out, first created the website, which I'm sure you all have seen. that we have. It's available in over 80 languages just by a click of the mouse. So all of the information about the plan to date is on that website. We also I probably get 2 or 3 emails still a week from the website that come to us with people with comments and things they want to see. So it's a really good way for people to interact with the plan that maybe couldn't make it to the meetings or thought of things after they had the meetings. We had our key leaders, staff, and stakeholder group meetings in February of last year. We met with many of you at those over a 2-day period. We also had our big community meetings on those evenings as well, in the middle of all the rain. Remember, that was the most rain. My colleague who's from Indiana he's always come to California, always looks beautiful, and he said it's rained for 2 straight days and I'm in California, so it was one of those rare times. We had our community meetings up at the event center at the Ingalls Hall. Good attendance there in spite of the rain. We were kind of worried about that, but we got a lot of good attendance there. For those of you who are there, we use a system called Mentimeter where people can log in to our presentation with their phones and give us real-time feedback so we can see what they do. And then we take all that information and download it for our report. We also did several of the community events. I remember seeing Kevin Bash out there and some of you, and Robin at the Concerts in the Park and Movies in the Park. Use the same system, Mentimeter, to do surveys. We had QR codes. We handed out stuff to them in person. The staff was great at helping us get those circulated. I think we did 4 or 5 of those and took all of that data as well into our report. We did a joint open house with the general plan in November, where we had an entire station set just for the Parks and Rec needs assessment. You can see the table in the back. We had sticky notes on all of the different things that people wanted to see in each of the parks. So we took all of that, and all that's been downloaded into our report system as well, which will show up in the final recommendations. We then used the flash vote that the city uses to do a couple community surveys, one on parks and facilities, and you can scan the QR code for the full results if you want that. And then this is just a summary of how many participated in those surveys. So we did the parks and facilities. We also did one, then we had open-ended comments on what people wanted to see. So the bigger the number, or the bigger the word, the more times that was used in the report. And that's all, again, all downloaded into our overall system for the final report. We also did one on recreational programs at a different day. It was like 1 week after the other, and got similar results on that. Again, you can scan the QR code for the full results. And then, again, had open-ended comments that we compiled as well. Just to so you know, too, that all of the initial survey stuff we did with the community meetings and with meeting with the community leaders and the stakeholders was to generate the questions that we use for this survey. So we don't just do standard survey questions that we do in every city. We tailor them just for Norco, and that's why we did all the meetings early on, so the survey questions applied to what Norco residents wanted to see. Had our staff visioning workshop. We do this after we have all of our findings. We meet with the community services staff where we go through about a 4-hour session, downloading all the data that we've seen so far, getting their input on that, and then having them give us their recommendations. And I will say the staff has been amazing with the challenges Michelle has had. Alejandra's really stepped up, and and the rest of the staff with Amanda and her crew. And Kelly have all been just really instrumental in making sure this thing moves forward at a good pace. So it was really good, and we have a full report on that as well. That is pretty much it. The next steps are creating what we call a level of service, which takes all of the elements you have in the city, compares those to national averages, and we decide then with staff which ones are going to be priorities. Obviously with Norco, we want to make sure we include equestrian, and so we'll be comparing some of these averages to other cities. My colleague who was with Next Practice Partners is Indiana, and he also does these around the country, which is why we like using him. And so he's got data from other cities around the country that are agricultural based, so we can compare some of these two to help you develop some standards that will help you move forward. We'll then be doing what we call a gap analysis, where we look at all of the elements that we have, whether it's a playground, a round pen, whatever it is, and we find out where those are, and we do a GIS map that shows you where the gaps are, where you don't have the things that the people want. So that'll be part of the next step. Then to the CIP, so then we'll start putting together numbers and recommendations and costs for all of this, and then a draft report and a final report, which probably will be somewhere around May, maybe early June. And we'll be back here to present to you and get your input and then get a final approval if we're ready to go. So that's it. Any questions you have, I'd be glad to answer them.
Thank you. Does council have any questions, comments? Greg?
Yeah, I was at that meeting a year ago, and it was brought up about pickle courts. And when I was looking at it had no mention of pickle courts.
Oh, on
in
the
it.
MPI?
Yeah.
Yeah, they don't have that, they're just getting those on there. So
Right.
those are just what they do the survey on. We grab that data,
Right.
but those are definitely on the radar for the
Okay,
city. So, yeah.
because that was one of the big topics.
Oh, yeah,
that
no,
came
that's,
up,
yeah, the MPI ratings are not necessarily what the city residents were asking for. It's just another database that we use to help us and analyze all the.
And then, along with what you said, like having someplace to tie your horses, horse ties,
Yeah.
corrals.
I designed Pike Street Park with a
I
little
know you
corral,
mentioned
so.
that, but that was,
It's
that
a
was
big
on my
deal to me.
checklist to
Yeah.
ask you.
Yeah, it's a
But
big deal.
that's
to
all
me.
I got.
Okay, thank you.
Just real quick on the, and I'm glad to see this, I'll call it like on the demographics, on the community service programs. Will this be further in depth that programs that we have that are not attended or low attendance by Norco residents that maybe we don't need to offer?
Yes, we look at the life cycle of the program, so whether it's new and exciting and being used to where it's, maybe not being used at all. And so some of those need to either be re-envisioned or just removed and new things added. So the data we got from the public on what they'd like to see in the rec programs, those will go into that report. And so, yeah, if you want to see, we have a detailed report that you'll see on that whole program analysis. But yeah, I would definitely recommend ones that maybe need to be, a little updated or removed and brought in as new.
Okay, great. I appreciate your time.
All right, thank you very much. Appreciate it. Have a good evening.
Okay, city council reports on regional boards, and we'll start with Councilmember Bash.
We had the WRCOG general plan review and update, which we kind of did our mission statements and reevaluated. And I think I sent that all to everybody, the results of that. Norco College President's Advisory Committee, nothing really happened there. The one thing that came out of the League of Cal Cities Riverside Division meeting was I had a conversation the next day with the woman who gave the presentation. And one of the things that we might want to look at is a climate resilience district, establishing those. What that does is if you show that, you have a certain roofing in your general plan, if you have enough fire hydrants, if you have a plan to keep city trees trimmed, you do certain things, what happens is that you then maybe get a break in terms of fire insurance. And so I think that, if you have enough stations, if you have just all the kind of things that I think we have most of, and it doesn't infringe on you forcing people. You can recommend people trim trees away from their roofs, but you don't have to. It's really, you create a district, and what you hope is that people will join into what you're doing in the district. One of the other things that she talked about is that, and we're all hearing about it, is that most cities have non-defensible areas. And so part of your climate resilient district would be you limit the number of non-defensible areas, like we were talking about Eastville earlier. They have a whole bunch of these really high buildings, and so they're in the process of buying a ladder truck because if you have 10 of them, you might be able to put the fires out of 2, but you can't get the rest. And so you limit the non-defensible areas. So I thought that was pretty interesting, and if we could look into that, I think it'd be a good deal to help us with fire insurance, because I think when the rates go up or the tiers go up, I think we're going to be in serious trouble. That's all I have. Thank you.
Thank you, Kevin.
Nothing to report at this time.
Nothing for me, not yet.
Nothing to report. Thank you, Mr. Mayor.
Last Thursday, attended the Chino Basin Desalter Authority Board of Directors meeting, and not too much to report from that. So, Call upon the clerk for public comments.
This is the time when persons wishing to address the presiding governmental body regarding the consent calendar or matters not on the agenda may be heard. Please limit comments to 3 minutes or less. The governmental body shall not discuss or act relative to any general public comment. And our first speaker is Rocky Lostetter.
Good evening.
Good evening. Thank you. I have a packet for everybody to take a look at. There's photos attached and some dimensions and stuff on it. I received a citation for encroachment on the horse trail. And all I was doing was I was putting pavers in to eliminate the erosion and the wash away of the horse trail to my neighbors. So my address is 2330 Norco Drive, and I added pavers for safety and erosion, and it would stop the erosion that went into my neighbor's, Mr. Ed Pullen's property, which is next door. He's at 2350 Norco Drive. I have a letter from him, which you have a copy of it, and he's 77 years old and he's disabled. And every time that it would rain and it would get the horse trail would just fill his backyard, not his backyard, but his driveway up. And I'd be out there shoveling it and getting it out, and the city didn't do anything. I called the city a couple times and I never had any response. Ed Pullen, he's in a wheelchair, and when the erosion would come, I would take care of it. All they would do is they'd come out and they would install sandbags, but the sandbags would get ripped apart by the horses and everything else, and it would just end up down in his property anyway. Therefore, I installed 2 foot of pavers at the end of my driveway, and also next to the street to stop the erosion. Fact is, there is still 12 foot of horse trail in front of my house, along with 12 foot of horse trail in front of Mr. Pullen's house and my neighbor to the east at 2310 Norco Drive. We always think safety, 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 and I had a horse get hurt in those ruts about 2 years ago, and it cost me some money for the vet. But I never reported it. I just took care of it myself because I felt that they're not going to come out anyway. When I was given the citation, Sam Nelson came out from the city, told me that I could move the pavers next to the street. Or I could keep the pavers next to the street, but I could move the pavers that was at the end of my driveway. I could move them over to the next to the street. It doesn't make sense. You still got 12 foot of horse trail there, and they can use it. So I don't understand why they're making me take these pavers out, because it helps. The city allows the pavers next to the street, but not extending it to my driveway. In conclusion, I'm asking the city council to allow these pavers to remain, because it's a lot of work for me, and I don't want to get it done. I'm 70 years old myself, and I'm trying to help a guy 77 years old, and with these pavers in, there's no erosion, and it diverts the water, and they work. So I don't understand why I have to take them out.
Thank you for your comments.
Thank you.
Thank you.
Our next speaker is Trisha Autry.
Good evening.
Good evening, Mayor. Good evening, council members. My name is Trisha Autry, and I'm your newest Parks and Recreation Commissioner. It's nice to meet all of you. I started back in August, and I've been very thankful for the opportunity to support our city in this capacity. Before the holidays, I was given the opportunity to meet with our teams in our community services and animal services departments and tour all the facilities that support the incredible work that they do in this city. As most Norconians, I am an animal lover and took a big interest in learning about the inner workings of our animal shelter. I'd been there before, but not really understood all of the amazing things they do behind the scenes. I took time to speak with the team about their jobs and what it looks like when they go out on calls. It was this visit at the animal shelter that led me here to speak with you today. I am here to advocate for equipping our animal services team with radios to enhance safety for both the employees and the public that they serve. Currently, these dedicated professionals only have access to cell phones while out in the field. This creates significant challenges, particularly in situations where they're managing animals, often frightened or aggressive, and interacting with community members who may be upset or emotional. In these moments, they are required to retrieve their cell phone, locate the right contact, and then make a call. This process not only takes valuable time, but also demands their attention, forcing them to momentarily shift their focus from the potentially volatile situation unfolding in front of them. This lapse in attention can place both the officer and the public at serious risk. A frightened animal or an agitated individual can react unpredictably in mere seconds, and the inability to quickly and efficiently communicate for backup or guidance can exacerbate an already intense situation. Radios provide the immediate and hands-free method of communication, allowing officers to call for support without diverting their attention from the scene. Ensuring our animal services team has access to radios is not just a matter of convenience, it is a matter of safety. Radios are a standard tool for many public service professionals, from law enforcement to emergency medical services, because they enable quick, reliable, and coordinated responses. Providing this essential tool would better equip our officers to de-escalate situations and effectively and efficiently protect everyone involved. I respectfully urge the council to prioritize the safety of our animal services team and the public that they serve by allowing the purchase of radios. This simple but vital change would demonstrate our commitment to supporting the work of our animal services team, who works tirelessly to keep our community safe. Thank you.
Thank you.
Our next speaker is Jeff Cahan.
Evening, Jeff.
Good evening, Mr. Mayor, Council. First of all, I want to commend the city and staff on a very nice, touching ceremony last evening. Very well done, and just wanted to let all the staff know that the city appreciates, and I know the Sheriff's Office knows, as they've said many times, that Norco is their best city for support. I'm here tonight to speak as a resident who had his power turned off for about 36 hours. Not going to complain about that, but the topic of the fires obviously is on everybody's mind. I just would like to know, in light of what Kevin talked about earlier from his meeting, do we have a recent updated assessment and list of the fire hydrant, the ones that work, the ones that don't work? Do we know where they are? Do we know how many? Do we know which ones? I think it would be nice if there is one. Is it publicly available, just so that the residents can feel comfortable knowing that, you know, that I've got one right in front of my house. I'm pretty sure it works, but I'd like to know. Other people in other parts of the town may or may not know, and I think just having something like that, having an assessment done if it hasn't been done or whatever, and getting that published somewhere on the website or some kind of a communication blurb to say, obviously, this is a very important topic and the city's taken a look at, and we've, you know, and if we've got more than we should that are out of service, you know, why and how quickly can we get those back online? Because my neighborhood wasn't particularly in a fire zone, but I guess the circuit that feeds our neighborhood came through a fire zone. That's why we were in those public safety shutoff areas. But obviously, if something were, there was a couple of fires in the riverbed just up in near Mount Rubidoux and a few places just nearby. So clearly our riverbed could be a very tender dry spot for fires. So just having that assessment, if we don't have one, either have it, or if we got one, publish it would be great. Appreciate that. Thank you very much.
Jeff, if you'd like to speak with the Public Works Director afterwards.
Okay, I think I know who that is.
We do have an assessment. We've been exercising our hydrants since 2017. They're all mapped and they're checked. If there's some that aren't working, there's a work order that goes through that. But we've been on top of that for the last 7 years, or
Good to
now
know.
8 years.
Okay.
But,
I was pretty
further
sure, but I
detail
just
you
wanted to
can-
make- yeah.
You can get from Chad.
Fantastic.
On that. And I think it's a good idea if we do put something out in our social media platforms.
Thank you.
Thank you.
And our next speaker is Bill Naylor.
Hi, Bill.
Hi, Council. As you guys know, I love to get up here and tell you guys when somebody's doing something really good and then maybe raise some concerns about other issues. Tonight, I'd like to kind of answer what Jeff was talking about, because I know I'd talked to some of the council and staff previously about the fire hydrants here in town, and that I know when we were on Streets, Trails, and Utilities Commission, the city did at that time enter into contract, and so we do have a contract to have our fire hydrants serviced routinely, and the city's in pretty good shape on that. I know there are a couple of areas, though, that have had some issues, maybe because of valves that they can't, if they want to replace a fire hydrant, they're going to have to shut off a whole block or something like that. I'd like us to consider putting those up into some priority areas. It's very obvious with the fires that we've had here recently in LA area that when they weren't having issues with fire hydrants, and I know Norco has been on the cutting edge of trying to take care of these things ahead of time, but we still do have a couple of places, and I specifically mentioned, I know of at least one fire hydrant, if not two, that are on Hillside between 4th and 5th, that the city's known about it for a long time, but they say because of the length of time it would take to shut the water off on those residences in that area, they have not been able to make the repairs at this point. I think we need to push that up, and there are ways to get around it to get temporary water to do it. The city, Trish there mentioned something about the radios. I worked with a government agency for many years, and I was kind of surprised when I found out that the city really doesn't have a radio system, but they do use phones for most of the communication. But it would really be beneficial and much more safer if we had some kind of radio communication, not only with the animal control, but public works and park staff and things like that. They're out there at all hours of the day and night, and they only have a phone to fall back on. But just some things to think about. But like I say, the city has been doing very well on many things, and I compliment you guys for it. Thank you.
Thank you.
And our last speaker is Dylan Wemple.
Good evening.
Good evening. In light of recent wildfires and ongoing infrastructure challenges, it's crucial that the City of Norco make forward-thinking investments to safeguard both our residents and the community's future. Poorly maintained infrastructure and rolling blackouts put our residents and the community's future at risk. Rising utility costs force our residents to choose between safety and comfort, and tonight I ask the Council to consider implementing a rural resilience initiative and a strong small town plan to address these challenges. My proposal is for the City of Norco to invest in a community solar project at the Ingalls Event Center, where we can install a 4-acre rooftop solar array capable of generating 3.5 megawatts annually. This clean energy could offset rising electricity costs for residents and ensure a reliable backup power source in the event of emergency, all while providing substantial revenue to the City of Norco. At current rates, this energy has a retail value of $1.5 million annually, and as we know, energy prices are only going up. This projected savings could help lower utility bills for residents, support city infrastructure, and provide financial stability for Norco's future. With an average solar system lifespan of 25 years, the initial investment paying itself off in about 10, the solar would provide 15 years of additional revenue for the city to use. Other cities have enacted similar initiatives, such as Franklin, New Jersey, who receives much less sunlight than we do, which successfully deployed an array powering more than 150 households. By partnering with organizations like the Norco College and Grid Alternatives out of Riverside, we can tap into valuable training programs and create local opportunities for jobs while boosting our economic resilience. State and federal incentives can help offset these initial costs and, to the earlier point, make sure that we are taking advantage of situations that may reduce infrastructure burdens and insurance premiums. Initiative can be rolled out in phases, starting with the installation of the solar array and expanding over time to include battery storage and backup for residents. These additional steps will increase our energy independence and protect Norco from the financial strain caused by rising energy costs. I urge the council to consider this opportunity to invest in Norco's future, and let's take proactive steps to make a more sustainable, resilient, and self-sufficient community. Thank you for your time.
Thank you.
No further public comments.
Thank you. Okay, moving on to the consent calendar. Do any council members have any items that need to be pulled? Hearing none, I'll ask for a motion to approve the consent calendar.
Mr. Mayor,
Oh,
real quick, can I ask you to pull item number H for a question?
Okay, we're going to pull item 3H. Have a motion? Do we have a second?
Second.
Okay. And just, I don't want to pull this item, I just want to discuss it. Just very briefly, it's just a compliment. Item 3F, I think on a very positive note, as a community, that this was a request by a resident who took the initiative to approach a local business to donate this round pen, and then brought it forward through the process to staff. And I want to thank all of you and Amanda and Todd. This is the right thing to do. It's a good thing. And I'm glad to see that partnership between our residents and our staff working the way it should. So, I have a motion and a second.
All right. Councilmember Sullivan?
Yes.
Councilmember Bowen?
Yes.
Councilmember Bash? Yes. Mayor Pro Tem Grunmeyer?
Yes.
Mayor Newton?
Yes.
Motion passes unanimous. Thank you.
Item 3H.
Thank you, Mr. Mayor. I apologize for the lateness on my request on this. I just happened to see this item. I didn't read beforehand, but I wanted to request if Councilman Bowen would be willing to become the designee for RCRA, and I would be the alternate, only because all the other designees for the other agencies are elected officials, and I think it'd be better for the continuity in working with the peers that they're elected officials, and I'm happy to serve as the designee I've had in the past. So I just wanted to make that request.
The reason I left you as the primary, it was just because of the dynamics of the RCRA board. And if Councilmember Bowen doesn't have any issue with that being the primary, do you still attend those meetings?
Yes, everyone.
Okay, so you would be there anyways?
I would be there as support staff for Mr. Bowen.
Okay. So I don't have a problem with that. And since it's my decision, but I'll ask, are you okay with that? As long as you're okay with it. I am. No, it's not. It's actually a very important position because it has to do with our waste system and all our recycled water systems, and with the changes of that. So there is a lot of responsibility with that. And but I want to make sure that you still attend those meetings.
Yes, sir, definitely.
Okay.
Thank you for that consideration.
I'll go ahead and make a motion to approve item 3H. Have a motion and a second.
Councilmember Sullivan?
Yes.
Councilmember Bowen?
Yes.
Councilmember Bash? Mayor Pro Tem Grunmeyer?
Yes.
Mayor Newton?
Yes.
Motion passes unanimous. Thank you.
Thank you. Legislative matters. Item 5A, Community Development Director Robles will answer any questions on this, but this is a second reading on ordinance number 1127. And the recommendation is to adopt that second reading. I hear a motion?
Second.
Have a motion and a second. Colin, you have no input on this item?
No, Mr. Mayor.
Councilmember Sullivan?
Yes.
Councilmember Bowen? Councilmember Bash? Mayor Pro Tem Grunmeyer?
Yes.
Mayor Newton?
Yes.
Motion passes unanimous. Thank you.
Okay, moving into public hearings. Item 6A. Alma?
Good evening, Council. This zone code amendment, agenda item 6A, zone code amendment 2024-04. And what the zone code amendment is proposing is to update our noticing requirements for public hearings. I'm going to skip this. I'm going to go straight to the proposed amendment. So what the zone code amendment is proposing to do is to change our notification requirements. Right now, the code requires us to notify property owners within a 300-foot radius of a subject property. It requires us to notify property owners within a 300-foot radius. The proposed amendment is proposing to increase it to 600-foot or a 600-foot radius. Right now, our municipal code requires that a minimum of 25 properties be notified. This proposed amendment would increase that to a minimum of 40. And right now, site plans do not require notification. The proposal here is proposing that site plans also require notification to surrounding property owners. So that's pretty much the summary of the proposed amendment. As the council may recall, this was initiated by our council several meetings back. The direction received was presented to the Planning Commission in the form of a zone code amendment, and the zone code amendment has been recommended for approval by the Planning Commission, and staff is recommending that the City Council concur with that determination. And with that, I will conclude and answer any questions. Thank you.
Thank you, Alma. Does council have any questions of staff? I'll open the public hearing. Do we have any cards on this matter?
I have received no public comments for this item.
Close the public hearing and bring this back to council for any discussion and action. There's no discussion. I'll entertain a motion.
Mr. Mayor, can I read
Colin?
the title? Thank you. This is ordinance number 1128, an ordinance of the City Council of the City of Norco, California, approving Zone Code Amendment 2024-04, a city-initiated amendment to Title 18, Chapter 1843, hearings and appeal therefrom, Chapter 1868, accessory building use permits, and Chapter 1840, site plan review, increasing the public noticing radius requirements from 300 feet with a minimum number of 25 properties captured to 600 feet with a minimum of 40 properties captured, and to require noticing for site plan review applications.
Councilmember Sullivan?
Yes.
Councilmember Bowen? Yes. Councilmember Bash? Yes. Mayor Pro Tem Grunmeyer?
Yes.
Mayor Newton?
Yes.
Motion passes unanimous. Thank you.
Thank you. City Council staff and communications. Does staff have any comments, communications? City Clerk's office? Chad?
Thank you, sir. Just pick me.
I know you're jumping out of your skin.
Very excited to report. We actually.
We just can't wait.
We were, for me, I'm giddy as a kid. I'm happy to report that we finally were able to pave Valley Drive between 3rd and 4th today. So it's not meant to be a speedway, just people are interested in riding that way. But it was finally paved. I want to say thank you to the residents for being very, very patient. There's still work to be done, striping and other items to be done. We still have other segments of Valley View, of repairing the trenching of the work that's there and on 3rd Street. But it's a major accomplishment to finally have that done after almost 2.5 years, to have that project really in a place where it's almost finished. So I'm very excited for the residents that have been very patient. Thank you.
And all new water services in that area, and
A lot of improvements, so we don't have to go back there hoping for a long, long time.
so it's all completed except for finishing. Right, got it. Amanda? City Attorney?
No, thank you.
City Manager? Alma? Lieutenant? Where's your puppy?
Hello, council. I just wanted to take a moment, again, to thank you guys for last night, for being there, for Mayor Newton for coming up and speaking. I know personally how hard that was. And just to thank the city, Lisette, Amanda, and Kelly, among everybody else, Chad, for just really stepping up and showing the deputies. I mean, that meant so much to them. Like, they were just taken aback by the showing last night. So to you guys and to the city of Norco and everybody that was there last night, to the community, thank you so much for coming out. And I also just want to pass along the information again on the procession for anybody that wasn't there and anybody watching tonight. So the funeral service will be on Thursday, January 23rd for Deputy Corlew. And following that, there will be a procession from the church to the cemetery that will go through Norco. It will pass on 6th Street, which is the main thoroughbred we would recommend people setting up on if they want to show support to the Corlew family. There are other streets. We are going to be on Hamner to 2nd to the freeway, but I would say 6th would probably be, the best showing. So I would say it's relatively touch and go. Obviously, we have to get on the buses back into the procession. But if everybody's there by 1, set up by 1, that would be probably the best time. It may come through a little bit after 1, but if you're there by 1, you won't miss it. So thank you again.
Thank you, Lieutenant. Councilmember Bowen.
Amanda, you guys did an awesome job last night. Thank you. And thanks for taking all the heat, Chad. But that was a phenomenal thing last night. And it was just amazing what Chad and everybody with the sheriff department said about Norco, on how Norco is so pro law enforcement, because we like doing the right things. And I'd like to thank all your staff for helping. And sorry I hurt myself last night. Oh, by the way, your first aid kit needs more stuff. Thank you.
Robin. Fia. Kevin.
You're going to bring this up, the Don Penninger letter about honoring the saddle sore riders. And could we ask Billy Asali and Kelly Ciarto to maybe do a resolution for them, a joint resolution? It takes a few weeks to get it to the saddle sore riders. I think that might be appropriate because they have been part of the community for so long, and we maybe could have the mayor present it here in one of our council meetings or have one of them come do it, possibly.
Yeah, I have a copy of the letter, and what we'll do is, as mayor, I'll work the agenda with the city manager and the city clerk to find the right time. And
maybe get the resolution from the State Assembly and from Senator Gould, Congressman Calvert, do the whole deal. Could be fun. Thank you. That's all I have.
Okay. I guess my comments are also for general comments to thank Amanda, Kelly, Chad, all the staff for, I know how much time and effort you put into last night. And Lisette, you lead an incredible team. So with that, of a legal question first, or process, that I'd like to adjourn the meeting, but we're going to go back into closed session. Can I still adjourn the meeting and the special meeting?
No, Mr. Mayor, we should leave the meeting and the special meeting open. We'll go into closed session, come back, report on closed session, we can close the meeting out.
Okay, so I'm going to make a statement here, and
Actually,
this,
Mr. Mayor, I'm sorry, situational awareness. We can do an honorary closure of the meeting, and then we'll deal with the procedurals after.
okay, so we'll take this as an honorary closure. As all of us are aware, this has been a tragic week for Southern California, for our partners at the Riverside County Sheriff's Office, and also for our team at City Hall. Been a rough start to the year, so I'd like to keep in our thoughts our city clerk, Dana Roa, and her husband, who were involved in a pretty serious car accident the other day. And I'd like to take a moment of silence for Aubrey Rainey. She was the daughter of our building official, Steve Rainey. Aubrey tragically passed away earlier this month, and our staff grieves for Steve and his family. So if you would, please bow your heads for a moment of silence in her honor. Thank you. I'd also like to adjourn tonight's meeting in honor of Norco's motor deputy, Timothy Corlew, who was involved in an on-duty accident on January 8th. His selfless service and unwavering dedication to the Norco community will never be forgotten. Thank you very much for attending this evening. And we will now adjourn to closed session.
Going into closed session on conference with labor negotiators and anticipated litigation, one potential case.